Elsewhere, the Constitutional Division of the Kenyan High Court has dismissed an amendment to the Judicial Service Commission Act, which gave President Uhuru Kenyatta powers to appoint the Chief Justice and Deputy Chief Justice. The five-judge bench, led by the principal judge of the High Court, Richard Mwongo, ruled the amendment was unconstitutional, null and void. The judges said the amendment flies in the face of the Constitution as it infringes on the independence of the Judicial Service Commission and would have allowed the executive to manipulate and patronize the judiciary. Patrick Amimo has more.
When the National Assembly late last year made changes to the Judicial Service Act 2011 to allow President Uhuru Kenyatta choose the next Chief Justice and Deputy Chief Justice of the Supreme Court of Kenya, the Law Society of Kenya and human rights organizations condemned the changes, arguing it was an affront to the independence of the judiciary. The Constitutional Division of the High Court, led by Principal Judge Richard Mwongo, has given its verdict on the changes.
We declare that the amendment to Section 33 of the Judicial Service Act, Void Statute Law Miscellaneous Amendment Act 2015, was unconstitutional, null and void.
The National Assembly's Justice and Legal Affairs Committee had deleted subsection 3 of the Act through the Statute Law Miscellaneous Amendment Act 2015 and substituted it with a new section which provided that the Secretary of the Judicial Service Commission shall forward names of 3 qualified persons each for the post of the Chief Justice and Deputy Chief Justice.
To us, such a proposition would fly in the face of the spirit of the current Constitution, which is with respect to the appointment of judges, in which the people of the Republic of Kenya wanted a radical departure from the old system, where the appointment of judges could not be traced to any particular criteria.
Chief Justice Dr. Willy Mutunga will retire next month. High Court Judge Isaac Lenaola had issued temporary orders stopping the Judicial Service Commission from starting the recruitment of top judicial officers set to replace Justice Mutunga and his deputy Kalpana Rawal, pending hearing and ruling on this case challenging the amendment. Article 166 of the Constitution provides that the President shall appoint the Chief Justice and Deputy Chief Justice in accordance with the recommendation of the Judicial Service Commission and subject to the approval of the National Assembly. It adds that the President shall appoint all other judges in accordance with the recommendations of the Judicial Service Commission. The President is not meant to exercise any discretion or active role in the appointment process.
To provide for a mandatory 3 names to be submitted to the President, in our view, opens an avenue for manipulation of the process and even horse trading. To do so would open the process to contamination by the ills that informed the transformation in which Kenyans discarded the old process of appointment of judges, which was besmirched with partisanship, nepotism, negative ethnicity, and tribalism.
When any of the state organs steps outside its mandate, this court will not hesitate to intervene. Where the Constitution decrees a specific procedure to be followed in the enactment of legislation, both houses of Parliament are bound to follow that procedure. If Parliament violates the procedural requirements of the supreme law of the land, it is for the courts of law, not least the Supreme Court, to assert the authority and supremacy of the Constitution.
The High Court criticized Parliament for violating its standing orders and Article 10 of the Constitution on national values and principles of governance. The High Court has emphasized that the doctrine of separation of powers must be respected and that checks and balances must be observed not only to secure the independence of the judiciary but other independent commissions. Patrick Amimo, KTN News at the Milimani Courts.